Good afternoon. I love sovereign citizens and their complete lack of self awareness. These two posts by Alyssa G were made on my debunking Joshua Martinez's assertions from November 10th of 2019 video that I did. Joshua Martinez is a right to travel sovereign citizen who likes to believe that you don't need a driver's license. And it doesn't matter what the state says. He can go ahead and drive at will without a driver's license. So she says, she's quoting here from Thompson v. Smith, a Supreme Court ruling. She says the right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city may prohibit at will, but is a common law right, which he has under the right to life, liberty, and the pursuit of happiness. And then she goes on to say, you couldn't be any more of a statist. Zero self-awareness there, because she just quoted a court decision, and she applies great weight to it being a Supreme Court ruling. Now, this is not a United States Supreme Court ruling, so don't get all excited, but she wants you to believe it is. And she places great value in it, and of course, Supreme Courts are part of the judicial system, either the federal judicial system or the state judicial system. But either way, they are part of the government. They are part of the state. They are a branch of state government. A constitution is also an article of the government. Now, she's quoting here, right to life, liberty, and the pursuit of happiness, from the Declaration of Independence, which is whereupon the United States declared their independence to form their own government from the, Great Britain, British Empire. I don't know how you'd call it back then. Don't really care either. So zero self-awareness, but let's look at this. She is trying to argue, apparently, because this isn't really an argument, it's just a quote. She's trying to argue that there is some right to drive an automobile, and that this somehow supports that right to drive. And I don't believe that it does, because if you ever quote a case and give an attorney enough information to find the case, odds are he's going to find that case and read it and then tell you how wrong and dumb you are. And here she is. Okay. So that's the quote. Get that quote in your head. It's Thompson v. Smith, the right of the citizen to travel upon public highways, right? This is Thompson v. Smith. You may notice that this is a Virginia Supreme Court of Virginia decision from 1930. Carries a lot of weight, right? Well, let's see if we could find that language. Look, I found the language. The right of the citizen to travel upon the public highways and transport his property thereon in the ordinary course of life and business is a common right, which he has under his right to enjoy life and liberty, to acquire and possess property, and to pursue happiness and safety. You may notice that her quote is fucked up, because sovereign citizens can't do anything right. Is not a mere privilege like the privilege of moving a house on the street, operating a business stand in the street, or transporting persons or property for hire along the street, which a city may permit or prohibit at will. So this is what she is trying to quote ineffectively, but you may notice that it continues. Obviously, this isn't the end of it. The exercise of such a common right, the city may, under its police power, regulate in the interests of public safety and welfare, but it may not arbitrarily or unreasonably prohibit or restrict it, nor may it permit one to exercise it and refuse to permit another of like qualifications under like conditions and circumstances to exercise it. The regulation of the exercise of the right to drive a private automobile on streets of a city may be accomplished in part by a city by granting, refusing, and revoking, under rules of general application, permits to drive an automobile on its streets, but such permits may not be arbitrarily refused or revoked, etc. What it's saying here is that, yes, indeed, the city, in this particular case, because this is back in the day when driver's licenses and permits and driving automobiles was a fairly new thing, but the city at that time could permit it or not. And you say, well, what does that mean? And what that means is This is Court of Appeals of Virginia, 2017 decision, relatively recent. But what that means is driving a motor vehicle on the highways of the Commonwealth is a privilege subject to regulation. This is the Virginia Code section 46.2-300, which makes it a crime to operate a vehicle, to drive a motor vehicle, to drive an automobile on the public highways of the state of Virginia without a valid driver's license. So there you go. Now you're going to ask yourself, well, you know what? What if Thompson v. Smith is still good law? What if it means what she says it means and what she and to be fair, it is good law for the purpose of not allowing the administrative branch of the government to arbitrarily define who can and can't have licenses, revoking licenses based on who the sheriff thinks is a bad driver without any criteria. That's still good law, because in this particular case, they provided us a syllabus, and the part that got this remanded was that the principle that the rights of men are not to be determined by the law, the principle that the rights of men are to be determined by the law itself and not by administrative officers does not mean, however, blah, blah, blah. The legislature must declare the policy of law and fix the legal principles which are to control in given cases, but an administrative body may be invested with the power to ascertain the facts and conditions to which the policy and principles apply. So this is what they're going for. Basically, this allowed the chief of police to grant and remove ordinances, revocation, and it was too arbitrary. But this argument has been used in the past. I'm going to mark this right here so I can find it easily. This is a relatively recent Washington Court of Appeals case from 1986, where the driver in the state of Washington was trying to argue that she's constitutionally entitled to drive. She claims she is constitutionally entitled to the special status because she's not engaged in commercial travel. She relies primarily upon quotations from Thompson v. Smith. Although the Thompson court declared the right to travel on public highways an individual's common right, which he has under his right to life and liberty, the court also noted that the exercise of such common right may be regulated under the city's police power if in the interest of public safety and welfare. The city driver's license revocation ordinance at issue in Thompson was upheld except to the extent it granted broad discretion to the city's chief of police to revoke licenses. The issuance and revocation of such driving permits by a city is merely a means of exercising the police power of the state delegated to the city to regulate the use of the public highways in the interest of public welfare and safety. So the court looked at her attempt to throw this particular language out, and rejected it. Now, I don't have it up, but if you do try to Google Thompson v. Smith and right to travel, you'll get a bunch of nonsense along the same lines. Here's a hint, Alyssa. Try actually reading the case before you cite it. Try understanding what the case means. Don't just take a grab bag of quotations off some random website and throw it out there thinking that anybody gives two shits about it, because it doesn't mean a damn thing. Thanks for watching, and have a great evening.